But he's saying that, I mean, if it were like blood, like some kind of tearing of the skin, that's one thing. But bruising, is it possible to get a bruise without feeling pain?
The affidavit she said she didn't feel pain.
I don't know. All I know
No, I'm
is
telling
that
you. That's why I'm up here challenging the PC on that one. There's an affidavit, a complaint that's provided.
There's an affidavit because in the
Hey,
DIMS,
this is on Corral. This is a new case, right?
It's a complaint. So it happened in October 2024.
How did it get an affidavit here so quick?
Because it's a complaint. The officer's affidavit on the complaint. He states that she stated she didn't feel any pain because she was fighting him as well.
But you said that you did feel pain.
reread pulled the complete DIMS.
I wouldn't, or that's the problem is the DIMS is maybe contradicting or inaccurate or different from the affidavit that I'm talking about. That the officer filed with the complaint.
So the complete DIMS reads, the complainant stated she did not feel pain at the time of the incident since she was fighting the defendant off of her, and that the officer observed the complainant shaking and crying, and the officer said, due to his training experience, I know being grabbed and bruises being left on her body causes pain. So according to the full DIMS, the complainant didn't say she felt pain. She said that she didn't feel pain at the time of the incident because she was fighting the defendant off of her. And that's what the full DIMS states. And the officer, based on training experience, saw the bruises on her and being grabbed and squeezed and came to the conclusion that it caused pain.
It could also be the exact, that what she said was, I was shaking and crying because I was fighting him. She's the one that says that.
I mean, I get it. Like at the time, you're in the stress of the excitement, so you're not feeling it. But then after
That's not what she said though, or that's not what
Stress.
they're going on.
Your Honor, the key thing the officer observed were the bruises on the complainant's arm. He observed the bruising and then came to the conclusion based on that. And what she told him, she did say that the defendant squeezed her arm. And based on that, her crying, shaking, and the bruising, he came to the conclusion that she felt pain due to that being squeezed.
I mean, taken as a totality, is that not sufficient for probable cause purposes?
I don't know. You have a sworn document where she says one of the elements is missing. And then everything else that he's adding is not in that
To
document.
be more specific, she's saying she did not feel pain at the time of the incident since you were fighting. She didn't say she didn't ever feel pain. She said at the time since she was fighting the defendant off of her.
But the officer
not in that.
But the officer never asked, hey, do you feel pain? Why
And
wouldn't you
the officer
ask?
never asked. He came to the conclusion based on totality.
Get it, but I don't know. I mean, I need to look up case law. I'm not sure. I don't know if that's enough. Because I mean, it's such a low standard for probable cause purposes, I mean, I get that you're saying that it's not alleged the pain as an element, but taken as a totality.
I guess you're saying taking as a totality. I'm saying that's a lot of speculation about stuff that's not in the DIMS or in the affidavit. Like you're making all these connections state.
I'm making the officer made the connection. He said in the DIMS, due to my training experience, I know being grabbed and bruises being left on your body causes pain. So
Right.
he made that
You
connection.
don't operate on hunches.
Right, and she's also stated that I was fighting him, so that could be because of her
I
fighting.
mean, here's the deal. Like if I find no PC, right, they may just re-indict it though.
That's fine.
No.
That's their.
Kelsey,
Yes, sir.
did you see what's going on? So in this case here, the officer never asks her, do you feel pain? He assumes she does just because of bruising on her arm. And because I guess they're in the stress of the excitement. So at the time she doesn't feel pain, but after a while, he assumes that she feels pain because of bruising on her arm.
And on body worn camera, he never says, we don't know.
But I mean, this is a probable cause hearing. We haven't seen it. So he wants me to find no PC. If I do though, right.
Well, if there are visible injuries, we can go from there.
But he's saying that, I mean, if it were like blood, like some kind of tearing of the skin, that's one thing. But bruising, is it possible to get a bruise without feeling pain?
Yeah,
You know?
all the time. if you fall downstairs and you're embarrassed more than in pain, you might be crying or shaking because you're embarrassed or excited, but it's not because of you injuring yourself down the stairs.
But Your Honor, that also ignores that she did say the squeeze itself. He mentioning a fall, but in this case, we do have a specific statement about a squeeze.
She doesn't say that she's in pain because of the squeeze.
So
I
if we
mean-
play it out in front of a jury, you would always have that statement saying at the time she didn't feel pain. Whatever you said contradicting that, that's fine, but it would not take away that statement that eliminates an element. So maybe a grand jury might find it different, but based on that DIMS, they have someone saying, I didn't feel pain. I think that's kind of like,
And Your Honor, I will say at the time, we don't have the full OR, so if you want to find no PC, we can revisit it. If we want to re-indict it, we can.
Okay, all right, I'll find a PC.
Hey,
No, no.
how you doing?
Dan?
Can we approach on something? I'd like you to hear probable cause and something.
Absolutely.
You have it pulled up?
Oh, yes, sir.
Okay.
So it's for Klaba. Okay. On January 15th at approximately 6 PM, officers initiated a reverse prostitution investigation. Undercover officer saw defendant parked near where she was standing. Defendant rolled down his driver's side window. Officers approached the defendant and had a conversation sexual in nature. Defendant agreed to engage in sexual intercourse with the officer in exchange for $100. Defendant and officer arranged to meet at a motel. Defendant started driving in the direction of the motel. Defendant was then stopped and identified by marked units. During this, officers located a loaded firearm behind the front passenger seat.
During the search incident, sorry.
So it would have been yeah. My argument is that the possession of the gun was not while he was engaged in this alleged criminal activity.
And we would understand where he's coming from, Your Honor. However, he did have the loaded firearm behind the front passenger seat, and this was search incident to arrest. So that's where we would be at.
We have the unusual circumstance here of my client is an aircraft mechanic. He works over at IAH. As a result of the gun case, not the solicitation case, the gun case, he lost his job. He can get it back because he's a member of the union. But the gun case is the only problem because he was charged with a gun. He lost his job. Now, I assume we're going to be able to work out the solicitation case with the
I
stand.
mean, I'm sure would probably work out in conjunction as well, you know, I mean, it's,
So, but in the meantime, he can't work. So,
let me read the statute. Hold on.
That one will have to finish ours. Oh, what if he's one of the seats?
I tried to replace my plumbing, but I forgot to shut off the water. All you gotta do is glue stuff.
So I'm looking at 46.02. Unlawful carrying of a weapon. A person commits an offense if the person, one, intentionally, knowingly, or recklessly carries on or about his or her person a handgun at the time of the offense. So is this at the time of the offense? Right? I guess there lies the question.
It was while he was proceeding to the motel where the incident, that they agreed to would occur. So during the process.
So, because, I mean, the offense is committed when? When the actually agreement took place.
Requires the way the charge reads, it requires, the offense is complete at the time that an agreement is
reached.
made. So
The agreement is made at the time allegedly when they're stopped. They had the wherewithal, if they wanted to, arrest him at that time, where subject to arrest at that time, they could have made the charge, so to speak, right? But they decided to wait.
Well, Your Honor, if I may, the statute reads they had honor about his person while committing criminal activity, and the firearm was in the vehicle while the offer was being made. It was just on the way to the hotel or the motel is when they stopped him and search incident to arrest for that solicitation. That's when they found the firearm. But the firearm was on or about the defendant's person while he was engaged in the offer for the solicitation.
And also, if I may, Judge, I would also say it would make sense for safety procedures for them to make the arrest while he was on the way to the motel so that they could have followed him and it wasn't just that undercover officer there at the scene and making the arrest.
I don't know, because they could have arrested him at the time, right on the spot. I don't know why they would try to bolster the case, I guess, by saying that there's more evidence of guilt by actually going to the motel. I mean, theoretically, they could have arrested at the time that the agreement is made, right? It's a contract.
Judge, I think we would just stick to the way the statute is worded is while engaged and the firearm was there. And they could have arrested him earlier, but as Mackenzie knows, they do that routinely for safety purposes as well as perhaps as you mentioned, they could have done it for further evidence as well, further investigation.
Prostitution cases I've seen is they arrest right on the spot, right then and there. They don't wait. I mean, the offense occurs right then and there.
And the offense did occur while the defendant was in the vehicle. That's when the offense occurred. He was in the vehicle when they made that agreement and the firearm was in the vehicle. They found it right after they followed him to the motel. It was in the same transaction.
The offense was complete.
I agree with you. I'll find no problem. Okay.